Hello and welcome. This is part 3 of the Memorandum in support of petition for Writ of Habeas Corpus under 28 U.S.C. subsection 2241. And again, it is Karen Reed versus Norfolk County Superior Court and the State Attorney General of Massachusetts. Before I get into page 16 of the memorandum, I wanted to share this excellent comment. DJI 9424 left this comment on the Writ of Habeas Corpus Part 2, and it reads, "The application of lesser included charges has always bothered me as being improper and a violation of due process. It always leads to overcharging, and as such, violates the cardinal principles of due process. The prosecution should never prosecute any charge that they cannot prove beyond a reasonable doubt. With properly collected evidence, but most importantly, they should not receive multiple attempts to convict. Rather, they should have one charge for each alleged offense. Anything more than that unfairly shifts the advantage to the prosecution." Excellent, excellent comment. And if you guys aren't aware, it's really about count 2, the lesser included charges on count 2, which again, the jury in the first trial were stuck on. And it's really about the BAC level, as I keep saying. And they should really throw out that BAC level, as I keep saying. You know, what's amazing, guys, is that the defense team was informed about the video footage of Brian Higgins arriving at Canton PD and making a phone call after 1 a.m., even though he testified during the first trial that he did not make any phone calls, right? And the fact that Brian Higgins had been drinking. He was drinking at the Waterfall Bar and Grill. It's captured on video. But somehow, not even an hour later, Brian Higgins is able to drive himself to Canton PD. So why didn't he get tested for alcohol? Like, why wasn't his blood alcohol level tested? You know, I'm just saying, I think the Karen Reed defense team has a strong argument here to completely throw out the alcohol level because it is prejudicial against Karen Reed when we consider that no one else's alcohol level was tested that morning. No one else. You know, it's not right. It's not fair. She was unjustly isolated. She was unjustly accused shortly after John O'Keefe was murdered. You know, she was immediately pinpointed as the primary suspect. And as a result, everyone else was treated like witnesses. And we saw that during the trial. The real culprits, to all of us paying attention, the real culprits were treated like innocent witnesses. So thank you to DJI 9424 for your excellent comment. And guys, DJI regularly comments on my videos, and they always have excellent perspective on what's going on with the case. Okay, we are on page 16, and it reads, "Although in other circumstances, quote, a reviewing court may defer to the trial court's discretion to make a mistrial decision, if the record reveals that the trial judge has failed to exercise the sound discretion entrusted to her, the reason for such deference disappears," end quote. Excellent quote. I'm going to read it again. Although in other circumstances, quote, a reviewing court may defer to the trial court's discretion to make a mistrial decision if the record reveals that the trial judge has failed to exercise the sound discretion entrusted to her, the reason for such deference disappears, end quote. And as I said in part 2, guys, Judge Bev displayed zero caution. Zero caution. She declared that mistrial in a hurry, for sure. And even the ACLUM, guys, if you refer back to the ACLUM amicus brief, they even described Judge Beverly Cannoni's declaration of the mistrial as hasty. I used the word hasty in part 2, and it wasn't me who said it. It was actually the ACLUM. Absolutely. Continuing. See also Commonwealth versus Stewart, stating that deferential review of a trial court's exercise of discretion as to when to declare a mistrial is appropriate, quote, only if it is clear from the record that the judge has given careful consideration to the available alternatives and to the defendant's interest in having the trial concluded in a single proceeding, end quote. You guys see that? Excellent citation. Yes, only if it is clear from the record that the judge has given careful consideration to the available alternatives, which we all know Judge Bev did not seek a single alternative, and to the defendant's interest in having the trial concluded in a single proceeding. You know, and as it's been documented, the defense team did not object, but the defense team was not given an opportunity to object. Continuing, here the SJC at the outset committed legal error by relying heavily upon the trial court's discretion, notwithstanding that the record reflected no consideration of any alternatives to a mistrial, i.e., no exercise of such discretion. Excellent. Yes, as I was saying in part 2. And guys, just so you know, I'm not reading this ahead of time. We are reading this memorandum together for the first time. If you haven't read it yet, like I haven't read it yet, I'm reading it with you. Guys, it's actually one of the reasons I started this channel was to research the Karen Read case and to document my research of the Karen Read case and to share my research of the Karen Read case with all of you who also want to be educated about the Karen Read case. We are learning about this memorandum together. Yeah, it's the same with court proceedings. Like when I don't have time to watch a hearing, I will provide commentary about the hearing, watching it the very first time so that my reaction to the hearing is genuine and authentic. So we are learning about this memorandum together. We are reading it together. And again, thank you for being here. But this is an awesome sentence. I'm going to read it again. It reads, here, the SJC at the outset committed legal error by relying heavily upon the trial court's discretion. And guys, in part 2 and part 1, I argued and vented about how the SJC merely copied and pasted Judge Beverly Cannoni's own arguments. And as an appellate court, the Supreme Judicial Court is supposed to provide more than just repeating what the lower court said. They're supposed to do more. You know, it was such a lazy decision, and it feels like it's yet more corruption. It feels like it's yet more bullshit. You know, and I really thought that the Supreme Court was going to be different. I really thought the Supreme Court was going to like look at this case and like, wow, like, you know, like, this is happening in Norfolk County. What the hell is Judge Bev doing? What's going on over there? You know, nothing. All they did was defend Judge Bev, and that's exactly what the sentence is saying. At the outset, the Supreme Court at the outset committed legal error by relying heavily upon Judge Bev's discretion. Like, that's all they did. That's all the Supreme Court did. They copied and pasted Judge Bev's words as if Judge Bev did not err in her decision making, as if Judge Bev was infallible during the trial. Like, it makes zero sense coming from an appellate court. And this part, notwithstanding that the record reflected no consideration of any alternatives to a mistrial. Exactly what I said in part 1, part 2, and in previous videos, that there is actually no alternative to the mistrial on the court record. Because again, it doesn't matter how many times the prosecution and Judge Bev say it, the Tui Rodriguez is not an alternative to a mistrial. So virtually, guys, there was no alternative to the mistrial offered. So the sentence concludes, no exercise of such discretion. I am so glad that the defense is calling the SJC on it. They are calling them out to the federal court in this sentence. So grateful. Good job, guys. Continuing. Turning to the relevant factors, quote, the first thing to be noted is that the trial judge did not give counsel an opportunity to object or discuss with them the admissibility of a mistrial. I'm going to read that one again. Quote, the first thing to be noted is that the trial judge, Judge Bev, did not give counsel, the defense team, or the prosecution an opportunity to object or discuss with them the advisability of a mistrial. Again, Judge Bev, pulling away from the memorandum, Judge Bev asked for comments after the first note, and she asked for comments after the second note. But at the most crucial point, guys, at the most crucial point, when she's just about to declare that mistrial, crickets. Nothing. She just rails through and declares that mistrial, and she doesn't provide an opportunity for the prosecution to comment, and she does not provide an opportunity for the defense to comment. Again, it's a sua sponte order that she made. Sua sponte, on her own, without any motion, without any commentary, without any arguments from either side. On her own, sua sponte, judge declared that mistrial. Fuck the rules. Fuck any commentary from either side. This is my courtroom. I'm declaring that mistrial because I said so. And guys, this is also a reflection of the Supreme Court judges, that they're okay with that. They actually consider Judge Bev to be okay as a judge. They think that her declaring that mistrial in a hurry and without caution is totally cool. Like, that's the low bar in Massachusetts. The Supreme Court level has an extremely low bar. Continuing, upon receiving the final jury note, the court declared a mistrial and excused the jury without consulting counsel. Video footage, and there's a footnote, number 6, video footage reinforces the suddenness of the court's action and corresponding lack of any meaningful opportunity to be heard. At the approximately 5:47:25 mark of the video, the court took the bench and stated, quote, "The jury is at an impasse," quote, "in contrast to the procedure followed as to prior notes, this note was not read to counsel." Exactly. Pulling away, guys. Exactly. Excellent for the defense to go sequence by sequence. What actually happened in that timeline before Judge Bev declared that mistrial. You have to look at it. You have to go sequence by sequence to show the federal court what exactly went down. You know, and guys, the defense team tried this for the Supreme Court. The defense team went sequence by sequence for the Supreme Court. They spelled it out for the Supreme Court. You know, like, and it didn't make a damn difference. Anyway, yeah, in contrast to the procedure followed as to prior notes. What the defense is saying, it's like so different from what Judge Bev did for the first note and the second note. In contrast, such a huge contrast, like holy hell. And again, like how could you not see it as deliberate, intentional? She has the capacity, the wherewithal to seek counsel's comments after note 1 and note 2, but after note 3, at the most crucial point of the trial, you're gonna ignore the counsel? You're just gonna take it upon yourself? Yep. Okay, continuing. Instead, the court immediately called for the jury to be brought in. The sound of a door opening or closing can be heard, and then at approximately 5:47:55, a mere 30 seconds later, the jury arrived in the courtroom. Yep, there was no opportunity given to either the prosecution or the defense to comment whatsoever within 30 seconds, you know, before the jury returned to the courtroom. I'm going to read this footnote. It's actually a YouTube link. Footnote number 6 is a YouTube link to the first trial. Continuing. The court then read the note, which had not previously been provided or read to counsel, on the record. At 5:49:23, the court stated it was declaring a mistrial and immediately discharged the jury at 5:49:30, a mere 7 seconds later. These circumstances did not provide Miss Reed's counsel with a meaningful opportunity to be heard. They cite Ramirez case law, and in parentheses, it reads, finding lack of sufficient opportunity where, after hearing testimony regarding potential defect in jury venire, district court stated its intent to declare mistrial, then called for the jury to be brought in and discharge them. So they're citing that case law because in that case law, they found a lack of sufficient opportunity where, after hearing testimony regarding potential defect in the jury poll, the venire is like the group of prospective jurors. District court stated its intent to declare mistrial, then called for the jury to be brought in and discharge them. So that's a contrast to what happened in the Karen Reed case, because the district court stated its intent to declare a mistrial and then called for the jury to be brought in and discharge them. You see, like the district court gave counsel a heads up that they were going to declare a mistrial. Judge Bev, at no point in the entire timeline and that entire sequence, the moments leading up to declaring a mistrial, at no point did Judge Bev give anybody a heads up that she would be declaring a mistrial? And her response to this, again, the defense has argued this since it happened. Judge Bev's response to this is that the defense should have known that she was going to declare a mistrial. They should have known because of the Tui Rodriguez instruction. Like, that's not how you conduct your courtroom at the Superior Court level, Judge Bev. You don't leave it up to counsel. You don't leave it up to the parties, and you certainly don't leave it up to the accused to assume your next decision. You know? Like, just, again, it's Judge Bev. All right, continuing. In another case law, they're citing, in parentheses, finding lack of sufficient opportunity to object where, quote, the district court only addressed counsel after reading and confirming the verdict in open court to ask if there was anything else before discharging the jury. Again, again. Yes, excellent. I'm going to reread that. Guys, Judge Bev didn't do any of this. But other justices did. Other judges did. Finding lack of sufficient opportunity to object where, quote, the district court only addressed counsel after reading and confirming the verdict in open court to ask if there was anything else before discharging the jury. So multiple times, Judge Bev just railed through this mistrial. She railed through that declaration. It seems almost deliberate. It seems almost like it was planned. Like it's an inside job. You know? Like, she cares about them during note 2. She cares about them during note 1. But during note 3, it's all Judge Bev's court, you know? It's like by the time we hear about note 3, Judge Bev shows her true colors, that despite all that effort, despite all those weeks and months of testimony, despite all those hours with the jury deliberating, you know, well over through the weekend, like, despite everyone's energy that they expended to put this trial together, she's going to rush through. She's going to rush to declare a mistrial at the most crucial moment and not even give either side an opportunity to comment. And even after the fact, before discharging the jury, still no opportunity for either side to comment. Like, that's the real Judge Bev right there. The last 3 minutes of trial. That's the real Judge Bev. She showed us it's her courtroom. and then there's the SJC, the Supreme Court, being like, yep, it's her courtroom. Oh, God. Okay, continuing. Legal and factual content renders the trial court's action even more unexpected. Legal trial counsel was entitled to rely on decades of case law expressly requiring a, quote, full opportunity to be heard, quote, before the declaration of a mistrial. Steward, case law. There's another footnote, number 7. We'll read that when we get to the bottom. It continues, factually, in response to multiple prior jury notes in this case, the trial court had advised counsel of the contents and afforded them time first to consider and then be heard regarding any issues raised. Provides a citation. The trial court's deviation from that well-known and accepted practice with respect to the final note was a, quote, precipitate decision and reflected by a rapid sequence of events culminating in a declaration of mistrial, end quote. And that's the Brady Samaha case that they cited previously. Continuing, it also deprived defense counsel of any opportunity to raise issues or even discuss potential remedies with their client. Absolutely. Good job on the defense so far. Excellent work. We're going to read this footnote, number 7. See also Commonwealth versus Taylor, 486 Mass, Commonwealth versus Nicole, and Picard versus Commonwealth, Commonwealth versus Hurrigan. So they're citing multiple case laws applicable to this argument. Excellent. Continuing. Moreover, the defense respectfully submits that given the importance of double jeopardy protections and the profound implications of a retrial for a criminal defendant, an opportunity to be heard must, in order to be meaningful, occur after a reasonable opportunity for counsel to consult with their client. Yes. Excellent. And they cite a case law, United States versus Pierce. And in parentheses, noting in finding lack of manifest necessity that counsel had no opportunity to discuss the prospect of a mistrial with his client. Counsel for Miss Reed clearly had no such opportunity here. Excellent. And again, even though the SJC merely repeated what Judge Bev argued, all they did was defend her. They did give the defense a little bone, a tiny bone. They threw a tiny bone at the defense when the SJC agreed with the defense that they were not given an opportunity to object. They did not have an opportunity to object. So, to me, that should support the defense's argument when it comes to the federal court, that the Supreme Court doesn't agree with them when it comes to anything else, but they agree on this part, that there was no opportunity given to object. Continuing. The SJC erred in multiple respects to ruling that the trial court's prior consultation with counsel was sufficient to excuse the absence of such consultation at the pivotal moment prior to any declaration of a mistrial. Yes, I'll read that again. The Supreme Court erred in multiple respects in ruling that the trial courts, that Judge Bev's prior consultation with counsel, that Judge Bev consulting with the prosecution and the defense during Note 1 and during Note 2 was sufficient, was enough to excuse the absence of such an opportunity at the pivotal moment, at the most crucial point after Note 3. Before Judge Bev declared the mistrial. It's an excellent argument, and yes, good on the defense to again call out the SJC, exposing them to the federal court. Again, the Supreme Court is agreeing with Judge Bev. Both the Supreme Court and Judge Bev and the prosecution, by the way, all three parties agree with the logic that because Judge Bev is providing commentary and allowing commentary after Note 1 and then after Note 2, that the defense should have known that she was going to declare a mistrial after Note 3, that no discussion was necessary because of the trajectory of the notes. When again, like the defense said, at no point before Judge declared that mistrial did Judge Bev say she was going to declare a mistrial. So, considering this is a criminal case where everything should be literal and clear and spoken on the record, it's okay to assume that a judge is going to declare a mistrial in a criminal case? No. Again, what kind of standard is that? Everything should be clear. Everything needs to be communicated. Judge Bev needs to be thorough. and shame on the Supreme Court for agreeing with her. That's not caution, There's supposed to be great caution. It's not caution when you're expecting counsel to assume where you're going with this. Like keep up, counsel. Keep up, attorneys. You guys should have known where I was headed with this, even though I didn't say anything, You're supposed to read my mind. Like, fucking A, it's a fucking criminal court case. Continuing. First, the SJC erred in relying upon the trial court's solicitation of counsel's views in response to the first two jury notes. Those discussions related solely to the propriety of giving a Tui Rodriguez charge, which again, quote, is designed to urge the jury to reach a verdict, end quote, and presents a distinct legal issue from the declaration of a mistrial. Defense counsel's request for a Tui Rodriguez charge implies that their desire was not to have a mistrial, but instead to have the trial court urge this jury to reach a verdict. Yes. Like, duh, Judge Bev, duh, Supreme Court, Continuing. Second, the SJC was wrong in simply assuming that consultation regarding the third note would not, quote, have produced any fruitful alternatives, end quote. And guys, pulling away, I didn't even finish reading the SJC's decision. I was going to turn that into a multi-part series, but then this memorandum was published and I had to get on it because I figured they were going to cover the SJC's decision in the memorandum. And indeed, they have. And here it is, something I did not hear because I didn't finish reading the Supreme Court's decision. I'm going to read that sentence again. Second, the Supreme Court was wrong in simply assuming that consultation regarding the third note would not, quote, have produced any fruitful alternatives, end quote. I can't believe the Supreme Court said that. I can't believe they said that. Yeah, you weren't given an opportunity to comment during the third note, but it wouldn't have produced any fruitful alternatives anyway. Like, what planet are we living on? Like, what judicial system is this for the Supreme Court to have a retrospection here that to me is severely not applicable to what actually happened or what should have happened? The Supreme Court is saying the defense is like out of line because because any commentary they would have provided prior to the declaration of a mistrial would not have produced any fruitful alternatives. How can the Supreme Court say that? That's speculation. How can they say that? Where on the record is that even indicated? Like, how does the Supreme Court have evidence to come to that conclusion? They don't. They don't know what would have happened. They don't know what the defense would have said. Like, are they really are they really saying this shit? Like, so bizarre. Again, this is an appellate court assuming what the defense counsel's options would have been, as if they know the defense counsel's strategy in defending their client. It makes no sense. Like, for a Supreme Court, a collective of judges at the Supreme Court level to say things like that, to declare things like that, and on a court record that, again, is documented forever. They're exposing themselves. Continuing. this reading of the silent record against the defense is contrary to the clear Supreme Court case law, placing the burden of establishing manifest necessity on the prosecution. Excellent. Indeed, the SJC's opinion does not so much as mention the appropriate allocation of the burden to the Commonwealth. Excellent. And I didn't even finish reading it. Like I said, guys, I did not finish reading the Supreme Court's decision as when they affirmed Judge Bev's denial of the motion to dismiss. But here is the defense calling them out again. Indeed, the Supreme Court's opinion does not so much as mention the appropriate allocation of the burden to the Commonwealth. That both Judge Bev and the Supreme Court continue to put the onus on the defense. You know, the burden on the defense when it was, is, and will always be on the prosecution, on the Commonwealth. Again, like, what planet are we living in? Continuing. Moreover, as set forth infra pages 19 to 22, there were alternatives to the declaration of a mistrial here. So it is far from clear that consultation would not have proved fruitful. Excellent. I'm going to reread that one. Moreover, as set forth in the pages in this document, there were alternatives to the declaration of a mistrial. So it is far from clear that consultation would not have proved fruitful. Yes, this is the defense throwing the Supreme Court's words back at them. That, in fact, there were alternatives, and they're going to get into it in the next few pages. Continuing. The record is independently lacking on the second prong, as it reflects no judicial consideration of alternatives to a mistrial. Here, there was one obvious alternative: to simply ask the jury to specify the charges on which it was deadlocked, and or to ask the jury whether or not its final note related to all or less than all of the charges. Again, guys, I argued this in part 2, and again, we are reading this together for the first time. I argued in part 2 that all Judge Bev had to do was rely on Rule 27B, because Rule 27B actually prompts her to inquire about each charge. Rule 27B instructs Judge Bev to ask about the verdicts of each charge, each count, before she declares a mistrial. So here's the defense agreeing with me in their memorandum to the federal court. There was one obvious alternative: to simply ask the jury to specify the charges on which it was deadlocked, and or to ask the jury whether or not its final note related to all or less than all of the charges. Good job, defense team. Continuing. This option is apparent from the face of Massachusetts Rules of Criminal Procedure. Rule 27B. Yes. Okay. It's too perfect, you know? This isn't the first time too. I've read a lot of court documents in the Karen Reed case, and so much of what I argued previous to reading the court documents are included in the court documents, you know? Like, great minds. Great minds think alike. All right, continuing. This option is apparent from the face of Rule 27B, which states that, quote, we're getting into it, guys, quote, the judge may declare a mistrial as to any charges upon which the jury cannot agree upon a verdict, provided, however, that the judge may first require the jury to return verdicts on those charges upon which the jury can agree, and direct that such verdicts be received and recorded, end quote. Yeah. Again, guys, Rule 27B gave Judge Bev license. It gave her permission to ask about each count, ask about any verdicts on any of the counts. And she was supposed to follow Rule 27B before declaring a mistrial. And let's just read the citation here of Rule 27B. It in steps, guys, as I said in part 2, and as I've stressed in so many previous videos, Rule 27B is written in steps. And again, guys, Rule 27B is not some random rule, like it didn't come from the sky. It's a Massachusetts rule of criminal procedure. It is a rule and a procedure all in one. And it's written in steps. And let's go over it together. The judge may declare a mistrial as to any charges upon which the jury cannot agree upon a verdict. Judge Bev had permission to declare a mistrial on count 2. That's the only count they were hung on. However, it keeps going. Provided, however, and what's provided, guys? I went through this in a past video. I'm going over it again. What is provided? Because that's not the end of the rule. Okay? It's saying the judge may declare a mistrial as to any charges the jury can't agree on. Right? Provided, however, it's so crucial, it's so important, and that's why the defense team emphasizes it. They made it in bold print. Provided. That means that she can't just declare a mistrial on any charges the jury can't agree on. She has to first require the jury to return verdicts on those charges upon which they can agree. Right here. Provided, however, that the judge may first require the jury to return verdicts on those charges upon which the jury can agree, and direct that such verdicts be received and recorded. You see, guys? So, before declaring that mistrial, as I've argued over and over again in past videos, before declaring that mistrial, Judge Bev was supposed to go over the counts that the jury members did agree on. It's like Rule 27B needs to be more specific, apparently. Because it's not clear enough for a judge like Judge Bev, like a layperson judge, it's not clear enough for Judge Bev. She didn't even follow it. She didn't even cite it. Even though there were multiple charges against Karen Reed, and Rule 27B pertains to multiple charges against a defendant. So again, guys, it is written in steps. But I guess the steps need to be sequential. They need to be step 1, step 2, step 3, It's almost like Massachusetts needs to reword Rule 27B and actually make it literally steps, like a recipe. Like part 1, go over the jury verdicts that they do agree on. First, do that. And then you can declare a mistrial on any of the charges they don't agree on. I'm just saying, anyone listening in Massachusetts, you might want to revise Rule 27B, because Judge Beverly Cannoni proved that not even the judge understands it, right? Okay, I'm going to keep going, guys. Oh, and the last part is important because there were verdicts. There were verdicts on counts 1 and 3, and those verdicts were supposed to be recorded. They were supposed to be received and recorded. So, guys, actually, we were all supposed to be informed. Karen Reed and the rest of us were all supposed to be informed that Karen Reed was found not guilty of counts 1 and 3 before Judge Bev declared a mistrial on count 2. Continuing. In fact, the reporter's notes expressly indicate that such reception of partial verdicts is required before a mistrial may be declared for manifest necessity. And by the reporter notes, they're referring to Rule 27 of the Massachusetts Rules of Criminal Procedure. And they cite the reporter's notes here in parentheses, quote, "This rule also provides that the court may declare a mistrial in cases where the jury is unable to reach a verdict. However, it must first receive and record the verdicts which the jury can agree upon," end quote. You see, so Rule 27B is clear enough to me the way it's written. But again, Judge Bev proved that it can easily be misinterpreted to a prosecution's advantage, right? And to a judge's advantage. And to the Supreme Court's advantage. Holy shit. Even the Supreme Court, guys, Rule 27B went completely over the Supreme Court's head, you know? Just completely over their head. They don't even give a damn that the rules of criminal procedure exist in Massachusetts. I'm going to read that quote again. This is Rule 27B, guys. This rule also provides that the court may declare a mistrial in cases where the jury is unable to reach a verdict. However, it must first receive and record the verdicts which the jury can agree upon. As I said, guys, we were supposed to be informed that there were verdicts on counts 1 and 3 before Judge Bev declared that mistrial on count 2. And Judge Bev, assuming that the jury notes pertained to all the counts, is not anyone's fault but Judge Bev. Because again, had she followed Rule 27B, she would have no excuse, you know? There would be no room for her to bullshit anybody. But she thinks there is room for her to bullshit us. And there really isn't, you know? With or without following Rule 27B, there really is no room. Even without Rule 27B, she should have specified, she should have had the verdicts, the counts specified for each count. And again, because the judge is supposed to take great caution. And a judge who takes great caution is going to verify with the foreperson and with the jury that these jury notes were true and accurate before she declared that mistrial. Even without Rule 27B, Judge Bev still chose to be hasty. She chose to rush the mistrial. Continuing. Had the court inquired as to the existence of any partial verdicts and the jury articulated its verdict consistent with the statements of Juror A, Juror B, Juror C, Juror D, and Juror E, the double jeopardy implications would have been clear and decisive. Quote, indeed, with virtual unanimity, the cases have applied collateral estoppel to bar the government from relegating a question of fact that was determined in defendant's favor by a partial verdict, end quote. United States versus Mespolide. And they cite another case law, Wallace versus Heavener, in parentheses, quote, when the jury hands down a partial verdict, a final judgment is rendered on the counts upon which the jury has reached agreement. Yep. So you see, guys, excellent on the defense's part. They're arguing excellent case law here, and again, they are citing Rule 27B, and it's like the jury did what they were supposed to do. You know, even if the foreman failed to be specific in the notes, he failed to be specific as to which count the jury members were hung on, right? But they did what they were supposed to do. It's clear they had verdicts for counts 1 and 3. The jury members performed as a jury. And so procedurally, there was nothing out of place here from the jury procedurally when we consider that there were verdicts on counts 1 and 3, and they couldn't agree on the lesser included charges of count 2. So procedurally, the jury did what they were supposed to do. It's actually Judge Bev who did what she was not supposed to do. Again, like so much effort from everybody putting this entire case together, even the prosecution. You know, the prosecution made the effort to plant the evidence and to invert the video, you know, to botch the timeline, to exclude the hash verified extractions, you know, like the prosecution put forth effort to put this trial together, right? Filled with lies it was, you know, but they still put forth the effort to put the trial together. And then the defense put forth the effort to combat against the fake evidence and the fake witnesses, you know? So I'm saying everybody expended energy here, including the jury members. And it was Judge Bev at the very end who did not do her job as a judge. We are on page 20. Continuing, the First Circuit's decision in United States versus Toribio Lugo, 2004 case, provides a helpful analog. There, in the midst of trial, upon noticing, quote, that only 11 jurors were present, end quote, the district judge, quote, consulted with both the prosecutor and the defendant's lawyers, end quote, outlining, quote, 2 options, either postpone the trial until the 12th juror could be located or proceed with a jury of 11, end quote. Defense counsel, quote, conferred with her client and informed the judge that the defendant did not wish to proceed at that moment with 11 jurors, but rather would like to wait for a 12-member jury, end quote. Shortly thereafter, the judge learned for the first time, quote, that the missing juror had been absent during some or all of the earlier portions of the trial. The judge then announced that he was going to declare a mistrial because only 11 jurors had heard the evidence, and he did not believe that there was any way to cure that defect, end quote. The trial judge denied a subsequent motion to dismiss on the grounds, quote, that a mistrial was required by manifest necessity because only 11 jurors remained, and the defendant had refused to proceed with fewer than 12, end quote. The First Circuit reversed, finding that, quote, there was a clear alternative to a mistrial, proceeding with 11 jurors, end quote. While the district court had, quote, tentatively explored, end quote, that alternative, it, quote, never exhausted it. The court never offered, quote, the court never offered the defendant a choice between proceeding with 11 jurors or accepting a mistrial, end quote. In fact, quote, during the pertinent time frame, end quote, the court, quote, made no effort to ascertain the defendant's attitude or wishes with regard to the possibility of a mistrial. In view of these omissions, the record compelled a conclusion that the jury of 11 alternative was not adequately explored, end quote. This conclusion was dispositive because, quote, where there is a viable alternative to a mistrial, the trial court fails adequately to explore it, a finding of manifest necessity cannot stand. The present case reflects even less consideration of alternatives to a mistrial. While the trial court discussed the two prior jury notes reporting an impasse with counsel, it did so only in the context of deciding whether to give a Tui Rodriguez charge, and the court did not even mention the prospect of a mistrial. Absolutely. Yes, as has been argued over and over again, not once did Judge Bev say the word mistrial before she declared the mistrial. Continuing. The SJC therefore legally erred in finding that the trial court's response to the first two jury notes reflected adequate consideration of alternatives to a mistrial. I 1000% agree. The defense is saying that the Supreme Court legally erred. They were legally incorrect in finding that Judge Bev's response to the first two jury notes reflected adequate consideration of alternatives, when again, Judge Bev did not provide a single alternative to the mistrial. Continuing, quote, there is nothing in the record to indicate that the judge was considering a mistrial at that time. They're citing Brady. While the notes stated that the jury had reached an impasse on some, quote, charges, end quote, quote, the test is not whether the judge considered that she had a potential problem on her hands, but whether she accorded careful consideration to the defendant's interest in having the trial concluded in a single proceeding, end quote. Excellent. And that's what they were citing in the previous case law, that the judge took it upon themselves, his or herself, to say, I'm declaring a mistrial because there's only 11 jurors, when the judge should have given the defendant the option of continuing with the trial with 11 jurors. You know, that's entirely up to the defendant. But the judge took it upon himself to say, we're not continuing. It's a mistrial. And with this case law, it's similar. That in both instances, the judges are supposed to consult with the defendant before making the final decision, before declaring a mistrial. You know, the defendant absolutely gets an opportunity to speak up before the mistrial is declared. And that's how it's supposed to be. But again, notice how Judge Bev did not give Karen Reed that opportunity. Continuing, quote, with the record barren of any hint whatsoever that the judge was aware of the double jeopardy implications of her decision, end quote, the defense respectfully submits that this court cannot find, quote, that her discretion was sound, end quote. The statutory prohibition on ordering the jury to continue deliberations without consent, citing a case law, they're citing the Massachusetts General Laws, subsection 68C, was one among many factors that the trial court should have considered in consultation with the parties. The statute would not have prohibited the trial court from simply asking whether the jury had reached a verdict on any counts, or asking the jury whether its impasse related to all or less than all charges. Contrary to the SJC's suggestion, there is simply nothing coercive about asking a jury whether it has reached a verdict on some but not all separately charged counts. And it provides a case law, United States versus Armstead. And in parentheses, affirming instruction that, quote, simply asked the jury to report any partial verdict it had already reached, end quote, as non-coercive. Excellent. United States versus Cachigo. Because, guys, remember, Judge Bev and the prosecution and even the Supreme Court, they were all on the same bandwagon, the illogical bandwagon that you can't ask the jury about the results. Right? You can't ask the jury about the conclusion of their deliberation when Rule 27B gives you the license to do exactly that. Rule 27B gave Judge Bev permission to ask the jury about the results of their deliberations for each count. But after the fact, Judge Bev wants to swear, and the prosecution and the Supreme Court, they all want to swear up and down that you can't do that. You can't ask the jury about the conclusions to their deliberations, because that would be going into their deliberations, right? To Judge Bev and the prosecution and the Supreme Court, asking for the conclusion of the deliberations is basically the same thing as asking for the details of their deliberations. And it's not. It's two different things. By definition, factually, those are two different things. You can either ask the jury how they came to their decision, which is going into the deliberations, or you can ask the jury the conclusion of their deliberations. You can say, what were your verdicts on counts 1, 2, and 3? That's it. We don't give a damn about how you came to the answer. Just, what are your verdicts? And Judge Bev and the prosecution and the Supreme Court made it seem like that was too much to ask, even though, again, the ACLUM amicus brief went into it. The case law the defense team brought into their motion to dismiss went into it. That post-trial jury inquiries happen in the state of Massachusetts, and you don't necessarily have to go into the process of deliberations to know the conclusion of the deliberations. Yeah, it's like you got to spell it out, You got to spell it out because they want to gaslight us. They do. They want to confuse us, and they want us to think that they are arguing legalities when they are not. They're not arguing a damn thing. All they're doing is covering one another's asses. It's amazing how that this is how it started, guys. That's why we're all here. Is that the McCabe's and the Alberts and Higgins and the MSP and Canton PD, they pinned this on Karen Reed because they were all covering each other's asses. And lo and behold, the prosecution, Judge Bev, and the Supreme Court are also covering one another's asses. Yeah, so I'm going to make a part 4, guys. I think we're on page 22. Yep, 22. So part 4 will pertain to page 22 and onward. if you're still here, thank you for being here. And I greatly appreciate the new subscribers, the new commenters. It's great to see new faces in the comment section. I am really grateful that you guys appreciate what I have to say, and I'm grateful that we can learn about these filings together. We can go over these documents together, you know, because it's not just about watching the trial, and it's not just about watching the news. It's also about like reading into these documents, you know, and getting deep into this case. You know, these documents are everything. And the defense's attempts at saving an innocent woman, you know, it's all documented in these court filings. And in that way, they're like sacred, you know, if you think of it that way. In that way, it's precious. You know, these words structured together by Karen Reed's defense team. These are precious arguments in the pursuit of Karen Reed's freedom. So thank you all for being here, and thank you for watching.